Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Okay, Mr. Cosgrove?
Hello, Your Honor. Timothy Bradl from Mr. Kearney. Good to be with you.
Okay.
Good afternoon, Your Honor. Attorney Steve Boozang on behalf of Ms. Reed.
All right, let's deal with Mr. Boozang's matter. I'm not sure that it's necessarily, well, I guess it's denominated 24SW0004, but it really is a request for setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within the days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay. I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol.
If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Boozang presented in his opposition, which is the Commonwealth, having been in possession of the phone for an extended period of time, has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second. Yeah, so in your motion, the Commonwealth's motion, it says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought that there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from an affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the log-on information or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol. As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument through Mr. Boozang that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Well, there's no question that more than a year has passed and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive. But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrantless search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to test years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure, which so far I've seen no evidence that the SJC has changed, is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Boozang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And
Yes.
here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Boozang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly,
Right.
Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place.
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant. So the question is whether you have a case that that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones, or any other piece of evidence. You know, warrant authorizes the seizure of hiking boots, and there's a 1.5-year delay on doing DNA testing to see if the boots trudge through mud, or blood, or whatever the relevant substance is.
Sure, Judge. Well, I feel that the reasonableness in delays in obtaining a search warrant under the Fourth Amendment and Article 14 of the Search and Seizure Law requires law enforcement to act diligently to obtain a search warrant without unreasonable delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her 2 phones, and they have all that evidence from Mr. Kearney. They have, I think,
all right,
5 or 6.
I understand those arguments, but I'm still trying to find a case, if you have one, that comes up in the context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
You know, I don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, this I don't think would have came up if we just let it stay and didn't ask for the 2 phones. It was only after I asked for the 2 phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But okay. I think in terms of reasonableness and timeliness, Judge, I think, it's almost 2 years.
Okay, I'll take it under advisement.
And the matter, it does have a next date of December 5th.
You know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
I do, Judge. I don't think the Commonwealth, in the preventive medicine case, the defense has some say in who would be a part of the tank team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for the with regard to the protocol that's proposed by the Commonwealth. That was part of the frustration that I had with the papers as they came to me.
Crossing over. I understand, Your Honor.
Yeah. So there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the 2 phones. I take it you can make a backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
opposition to what?
To the tank team part of the the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay, not an elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before. Okay, it's not all that complicated. So I'll give you 10 days to do that. If that gives you folks enough time to confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
Always happy to talk to Mr. Boozang.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be. What are we? We're already October 8. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 1021.
Okay, so we'll await your responses. You have until October 21st. The matter is next on December 5th.
Thank you, Madam Clerk.
2 p.m. for hearing on the motions to dismiss. Thank you. I'll see you then.
Your Honor, may I be heard on the disqualification issue?
Mr. Bradl, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as an in re search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6? I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not.
until we-
I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure, I understand, Your Honor.
When would you like to schedule a hearing on that motion? Margaret, do you have? We could do December 5th, but let me. Do you have the motion for disqualification? I have an affidavit.
Sorry, Judge. There's an impounded and a redacted one. Redacted for the public docket, and there should be an unimpounded one, or unredacted one, rather. That's for the court. And I believe they were filed in all three of those dockets. The 24 and the 23 case for Mr. Kearney, and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but.
I think they might be downstairs because I didn't think
Sure.
today and the files are so voluminous.
Okay. What's the status of the 2025 case?
The
25 CR 88.
That's had a little bit of a back burner, Judge. I think there's a pretrial where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
That's correct. The 24 case on the part of Mr. Kearney, Mr. Cosgrove acknowledged and withdrew. The 23 case we contend
I'm sorry.
Sorry.
Say that again.
Sure. The 24 case on the part of Mr. Kearney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gattani is suing him and is also a key witness in the 23 case by the government's own admissions. The detective on the case swore to it in a
Yeah,
search warrant.
that's fine. So you haven't filed a motion to withdraw on the 2025 case?
Correct.
Okay, so we'll take up the 2020.
The 23.
We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th, in November at some point? And if we can't get a date right this second, can we report?
Oh, you can get a date right this second?
Okay.
We'll figure it out.
Sure.
December looks better to me than November, Your Honor, and part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradl has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office, is who should respond to the motion to disqualify me? Should I respond? Should or can the Norfolk District Attorney's Office respond, or should it be the Attorney General or someone else? So there are discussions underway as to who the appropriate person is to respond to that, and I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date, December 5th?
We do, Your Honor.
All right. It should be here, yeah. What? No. Yes, it should be in this session, December 5th.
Very good.
Okay? And that's at 2 o'clock?
Yes.
Okay?
Thank you.
So, Mr. Kearney, your matter is continued to December 5th for a hearing on the motion to dismiss and the motion to disqualify at 2 p.m. Thank you.
Thank you.
Thank you, Your Honor.
Okay.
May we have Mr. Cantave?